some amendments, people. What is these amendments? We'll just see these amendments. Okay, first let's look at easy ones. Okay, we have seen something called as compliance officer, if you remember. LODR, should the company appoint a compliance officer? Who will be a compliance officer? First class. Okay, we'll start. So these are the amendments they have come up with in LODR. So what is that, sir? If you remember in LODR, people, LODR, bachpan mein, we are done. If you remember, yes, so if at all you guys are appointing a compliance officer, who is compliance officer? Joy. You will. Hey, confidence. Okay. So now Joydeep became compliance officer. No, let us not take your example. Now imagine you took a compliance officer. What if a compliance officer leaves, vacates, or it can be death, it can be resignation, it can be any such scenario. In such case, within what time the next compliance officer has to come? They've given something on that. They are telling you any vacancy in the office of compliance officer shall be filled by the listed entity at the earliest try, and in any case not later than 3 months from the date of vacancy. So this provision is an amendment? No, this provision was already there, but to this provision they have made an amendment. Now what was that? There was certain scenarios, people, where the company will not be able to find the right officer within this 3 months. So what the companies used to do, they used to appoint some person temporarily so that they can appoint someone in the 3 months. They used to appoint someone because you want to appoint compliance officer, I'll appoint. So just for the sake of it, they used to appoint someone as a temporary person. Now they are saying, people, that is not possible. Now read the extended version. However, the listed entity shall not fill such vacancy by appointing a person in interim capacity unless such appointment is made in accordance with the laws applicable in case of fresh appointment to such office, and the obligations under such laws are made applicable to such person. Now what do you mean by that? Whenever you're appointing a person, if even you're appointing temporarily, that person has to satisfy all the appointment procedures, whatever a CS satisfies. Compliance officer, when you're appointing for the first time, whatever those conditions you are satisfying, all the conditions has to be satisfied again. If not, you cannot appoint a person in the interim capacity. Understood? Now this part is amendment. Is clear? Any doubt? Something happened there. Okay. Is clear? Yes, sir. Okay. Next one, sir. Again, easy one, na? Okay. Okay, there is next one. The following regulation 17, they have added something called 17(1)(d). What is 17? Regulation 17, bachpan mein, when you were 17-year-old, we have discussed this. Composition of board. Wow. People, we had seen something called as composition of board. Yes, sir. Yes, sir. It is composition of board only. She's telling no. Yes, sir. Now, people, there is something called as composition of board. What is the composition of board? Wow. Who all will be there in the board is composition. Shiradi. Okay. So if you remember that 50% executive or non-executive, already done da. Shiradi. Explaining Allah, we already done that. Illa. Skip that chapter. You were in Shiradi that time. Correct? Okay. The following regulation 17(1)(d) is added. What does that say? Shareholder approval required for appointment or reappointment, it seems. You need to take shareholders approval. When, why, what is this provision? Try to understand. With effect from April 1st, 2024, the continuation of a director serving on the board of directors of a listed entity shall be subject to the approval of shareholders in a general meeting. Meaning what, sir? The director appointed in a board of directors, his position, whether you're appointing him for the first time or whether you're reappointing, then in such cases you need to take shareholder approval, it seems. Now why is this, sir? To avoid a scenario where once a person is appointed, and he sits as a director forever. Imagine he's been a director in 1980. Infosys is there. Now he has been a director in 1990. Now Nandan Nilekani, chairman, managing director, 1990. Even till today, they are all directors only. Whether are they coming and are the shareholders? Everyday people are changing. But do you guys know whether this person is capable enough to continue as a director? The answer is no. He's continuing because appointed, once done, is done. They are telling if at all a person is appointed in such a way, then every 5 years once, at least once in every 5 years from the date of their appointment or even reappointment, as the case may be, you need to come and take the shareholders' approval. Understood? So, in short, sir, nothing but once a director is appointed, once in 5 years, you need to come. Again, shareholders has to agree. Only then you can again continue in the director capacity. Understood? Pakka na? Okay. However, the continuation of the directors serving on the board of directors of a listed entity as on March 31st, 2024, without the approval of the shareholders for the last 5 years or more, shall be subject to the approval of shareholders in the first general meeting to be held after March 31st, 2024. What is that, sir? Whoever are the directors as on March 31st, 2024. Now the question asked to you, hey, you directors, are you director on any company as on March 31st, 2024? If the answer is yes. The second question asked to you, have you taken any shareholders approval? If the answer is no. Then after March 31st, 2024, whenever you're conducting your first general meeting, in that first general meeting, you need to repeat this process. This is the immediate amendment. Going forward, once in 5 years. Okay, next one, sir. The requirement specified in this regulation, which requirement? They're telling you that shareholders approval requirement shall not be applicable to the whole-time director, managing director, manager, independent director. They're telling you it is not applicable to whole-time director, managing director, manager, independent director, or director retiring as per section 152 subsection 6. 152 subsection 6. Retirement by rotation. Yes, that was your doubt. So, sir, they're telling you these provisions shall not apply to these directors. That is, they are appointed in all these people and they are appointed according to 152 subsection 6. It is not applicable to them. For security law students, don't take it too much of too seriously. It's okay. 152.6 just says there is something called as proportional. The director by retirement by rotation. There is one concept that every director has to be in board for a certain period, and after that, automatically you will come and retire. If your performance is good, shareholders will automatically reappoint you. So this keeps on happening. So if you're appointed like that, then this provision is not applicable. Use your brain. Why? You're already coming and already shareholders are appointing you if your performance is good. Then again, it's the same provision, right? So they're telling you, you need not have to follow this provision again. Make sense, huh? Yes, huh? Okay. Okay, of the Companies Act, if the approval of the shareholders for the reappointment or continuation of the aforesaid directors or manager is otherwise provided for the provisions of these regulations or the Companies Act and has been complied with. Now, what they are telling you, they need not have to comply with these provisions. Why? They are already complying with any other provisions, or they are complying with provisions given under Companies Act. They are complying, no. 152.6 and all, they are complying. So they are telling you they need not again have to come through it. Why independent director is also coming here? They're telling even independent director, they need not do this. Why? If you remember, reappointment of independent director, you need a special resolution. So again, everything is happening in the same way. And can you become, how many years can you become an independent director? So there is 2 terms and all. So there is already the provision given to you. So that's the reason they're telling you you're not covered here. Understood? Managing director, you guys saw there is sections and schedules given for them. You're following that. You need not follow this provision again. I'm just giving you the other face of it. Understood? All of you? Pakka? Okay. So this is the second amendment. Any doubts here? No? Clear? Okay. Third amendment. The following regulation 17(1)(e) is added. 17(1)(d) again with regards to composition only. 17(1)(e) is also again with regards to composition only. What is it? Vacancy to be filed in the office of a director. If any director leaves, there will be a vacancy. You need to appoint someone in that vacancy itself. What is that? Any vacancy in the office of a director shall be filled by the listed entity at the earliest and in any case not later than 3 months from the date of such vacancy. Same words. Again it is repeated. However, if the listed entity becomes non-compliant due to expiration of the term of office of any director, the resulting vacancy shall be filled by the listed entity not later than the date of such a office is vacated. Now, what do you mean by that, sir? Let us imagine there are, okay, in a listed company, what is the composition of board? How many directors has to be there? Top down listed, 6 directors. Now, sir, if there are 6 directors, they are telling, of course, people, one thing you need to remember here, I'm nowhere stressing on a point that if the number goes below the minimum, I'm nowhere telling that. Let us imagine the company had 10 directors only. Let us take that scenario only. Don't get confused. Even in my company, if we had 10 directors, one director left the office. Yes, sir. They're telling you this vacancy has to be filled at the earliest, not later than 3 months at any given point of time. However, the same paragraph has a second point. What is the second point? It says, if this resulting vacancy, no, where is it? If the listed entity becomes non-compliant due to expiration of the term of office, expiration of the term of office. What do you mean by that? You have appointed, there are 10 directors. In this, one director was appointed for a period of 5 years. Now, whenever a vacancy is created, vacancy can be created in any way. It can be by resignation, it can be by death, it can be by removal. In all these 3 cases, they are telling you need to fill the vacancy at least maximum within 3 months. There is a 4th type of vacancy that can be created also. What is the 4th type of vacancy? You had appointed him for 5 years. Now his tenure is about to end. You know this 5 years is coming to an end. You know it is coming to an end. You know it is coming. Alva. You know Alva. Then whatever is this last day, before that only you need to appoint the person in his vacancy. Makes sense? All these cases can come like a notice period. It happens in your corporate. You have to at least stay for 3 months and go. So you cannot anticipate. A person is dying. I cannot anticipate. You should have told. That's the reason I've given you at least 3 months time. This need not require an anticipation. You know that it is 5 years. They're telling you before that only. That's the reason the last statement says it has to be done. Read this entire thing. However, the listener becomes non-compliant due to the resulting vacancy shall be filled by the listed entity not later than the date of such office is vacated. Make sense? You will understand that amendments they will ask you somewhere. That's the reason. Clear?
You said they'll put someone in the meantime, like 3 months. So even if there's nobody, there's not a problem for 3 months, sir.
It's a non-compliance only.
No, but like they're taking 3 months time to appoint someone. So in the meantime, if there's nobody,
non-compliance only. You need to pay penalty.
and appoint them at the earliest.
Correct. Yes. At any cost, you need to have a person. That's the main intention. Okay. The following regulation 26A is added. Vacancy to be filled in respect of certain KMP positions. That is key managerial position. Vacancies again. Any vacancy in the office of CEO, managing director, whole-time director, manager. KMP is the KMP. Where is CS, sir? CS you already saw, no, compliance officer. That's the reason CS is not there. Okay. CEO, managing director, whole-time director, manager shall be filled by the listed entity at the earliest, in any case, not later than 3 months from the date of such vacancy. Same point, Okay. Any vacancy in the office of CFO, CFO shall be filled by the listed entity at the earliest and in any case not later than 3 months from the date of such vacancy. You know, it is same provision, na? And CFO is also KMP, so it's the same provision. The listed entity shall not fill such vacancy by appointing a person in the interim capacity. Same thing, unless such appointment is made in accordance with the law in case of fresh appointment to our such a laws. Correct? Technically, they could have easily put a compliance officer part also here only. Provision is same for everyone because everyone is KMP only. Yes or no? Correct? Yes, sir. Okay. Now, we'll do one more easy one. Sir, do only easy ones. Difficult ones, leave it. It's okay. हम manage कर लेंगे. Okay. Sir, next ones are easy one. Special rights to shareholders systems. What is that? Any special right granted to the shareholders of a listed entity shall be subject to approval by the shareholders in a general meeting by way of special resolution once in every 5 years starting from the date of grant of such special right. What do you mean by that, sir? Imagine you are giving any special right to a shareholder. Shareholder. Can it be even a preference shareholder? Yes, it can be. Can it be a equity shareholder? Yes, it can be. So what they're telling you, if at all you are giving any special right to any particular shareholders, for giving this right, they are telling you, you need to make sure you need to take a shareholder's approval before you give that. And once you give that, is it like permanent, sir? No. Same thing will apply. What? Every 5 years once, you need to renew this approval again and again. Sir, these approvals, what is this special right can be? Imagine preference shareholders. You're giving them a special right. What is that? Imagine I'm giving them access to go and check all the register of members. I'm giving them more rights when compared to what generally was promised. In all these cases, they are telling you, you can do it. I'm not saying no. First, to take shareholders' approval. Second thing, it has to be renewed every 5 years once. Simple, lah? Done, nah? Done. Next one, sir. Read this. They have written it very trickily, but good one only. But framing could be a little better, but it's okay. The listed entity shall, I'll read, you guys try to interpret what it says. Start to interpret law. The listed entity shall subsequent to the listing submit its financial results for the quarter or the financial year immediately succeeding the period for which the financial statements have been disclosed in the offer document for the IPO in accordance with the timeline specified in 33(3)(a). I know we don't remember, that's why I've written 45 days, or 33(3)(d). I know, don't remember, that is 60 days from the end of financial year, or within 21 days from the date of listing, whichever is later. What is this? When you know we don't remember that, when you know you can don't, this also I should know, sir. Correct, huh? Yes, nah. So understood this one, nah? Who? Shirdi? Tell. Until 60 days, don't explain me at all. That whichever is later, I want. That's the entire interpretation. People, till here it's not amendment. This is the amendment. You don't tell me I'm interpreting first 4 lines, sir. One you interpret. Yes, sir. Okay. So, see what they're telling you, people. Let's imagine a company is going for IPO. Immediately, once the company goes for an IPO, and when they are going for an IPO, you give me a random date. When are they going for an IPO? Any random date. July 25. Yes, sir. July. Which quarter does it fall? April, May, June. Correct? July, I can explain you, but the provision still doesn't work. You give me another date. September. Okay, let's take. Okay, let's take Feb. February doesn't work, but it's okay. We'll see. So you take one date, sir, whichever you know. Okay. See, I'll tell you in short what they're telling you. Whenever a company goes for listing, now the company went for IPO. Let us imagine the company went for IPO on, let us take example of March 20th. Yes, sir. Now, what are they telling you people? Whenever a company is going for IPO, the company has to obviously, because it becomes a listed company, you have to disclose quarterly financial statements to stock exchange within 45 days of the end of the quarter, that we have already seen the provision. Within 60 days at the end of financial year if it's an annual disclosure. Quarterly will be 45 days, annual will be 60 days. Now what was happening, there were scenarios where a company was getting listed on a particular date and it was not practical for a company, they would not have much time for them to prepare the financial statements at times. Now let us take for example, I'll take a random example of a company gets listed on December 20th. Whenever a company is getting listed on a particular date, now according to the law, my quarter ends on December 31st. Now what are they telling you? You need to have something, at least a minimum amount of time for you to prepare your quarterly financial statements or your annual financial statements. Now that's the reason what did they do? They gave you a comparison. What is that? Whenever you want to disclose your financial statements, then compare it with this instance. What is that? You need to disclose the listed entity shall subsequent to the listing submit its financial results for the quarter or the financial year, meaning annual, immediately succeeding the period for which the financial statements have been disclosed in the offer document for the IPO in accordance with timeline specified in the regulation, that is 45 days from the end of each quarter or 60 days from the end of financial year within 21 days from the end of date of listing, whichever is later. Now what do you mean by that, sir? Now whenever a company is coming and listing, let us take for example on December 20th, they're telling you, for giving you some time, they're telling you compare this with your regular date and compare this with your 21 days. That's the minimum time you will get. Now what is that, sir? They're telling me compare it with 45 days from the end of the quarter or 21 days from the date of listing, whichever is later. By this day, you have to give a financial disclosure. This is applicable only for the time when the company goes for IPO. That's the first quarter, or if it is somewhere during March, it will come only during the time of March. Now let us take it this way. A company has gone for listing on April, let us take for example, let us take on May only. Company goes for listing on May 15th. Is the annual financial statements, is it ready? The answer is no, because I still have time. I have to prepare it within 60 days. I'm still in my May 15th. I still have time. Now company goes for listing on May 15th. Technically, when should I submit my financial statements to the stock exchange? I have to submit it by May 30th. Correct? Huh? Why May 30th? Whenever my financial year ends, you have to calculate 60 days from then. So I have to technically submit my financial statements on May 30th. Now for you, you have another 15 days time. So in such scenarios, what will happen? You will get 21 days. So calculate 60 days from the closure of financial year or 21 days from the date of listing. So 21 days you can calculate. It can be May 16th, 26th, next one. What is it? June 6th. So it will be June 6th instead of May 30th, whichever is later. You will get that extra 6 days or 1 week time. So when will this help people? When you're exactly falling in that time, when December 20th, December 15th, or imagine I come and I list myself, which was that company, LIC or something. It got listed on Feb 10th. Now Feb 10th is, now according to all the companies, LODR regulations, by Feb 15th, you have to report your December quarter financials. You have to report. According to the LODR provisions, once a company is listed, because there was no exception, you have to report October to December. Papa, they just got listed, Feb 10th. In another 5 days, they have to report. They don't have a choice. Now, it becomes Feb 15th or 21 days from Feb 10th. That will be March 21 days. March 3, whatever you say, I'll write off. Which year? Leap day na, oh my god, 23. March 4. So now it will be March 4th or Feb 15th, whichever is later. Instead of disclosing on on Feb 15th, you can disclose on March 4th.
Quarter 25 days only. From the end of each quarter. When you have to submit the financial
45 days. So for December, I'll submit it within 45 days. For the financial year, I'll submit it within 60 days. Is clear? All of you, this is the amendment. Understood? Any doubts here? Feb 25th? Okay. Sarvesh, Feb 25th is different. वो आपका results financial results अल्ला. Okay. Done now? Okay. Okay. Next we'll start with the last amendment, regulation 30. Tax started. Direct tax. Okay. Now, people, there are some amendments in regulation 30. Now, I've given you some amendments in your book. I've given you that. But to understand the complete regulation, you need to know what the complete regulation is about. Then you will understand what the amendment is, because they've just given you some 3 sub provisions. But the entire regulation is not given. It wasn't there also for us. So for you to know what is the amendment, you need to know what is the regulation. So that's the reason. Now, what is regulation 30? Regulation 30 spoke about something called as disclosure of events or information. Now, what is this, people? Simple. Whenever a company, let us imagine, what is the amendment also, I'll tell you. Now, whenever there are some rumors on the company, you'll be seeing one topic also. Tomorrow we'll be discussing that, prohibition of insider trading. A company, whenever there are rumors against the company has to come and give a disclosure. What is this rumor? Is this rumor right or wrong? You have to give the clarification. There is an obligation on the company. Now the question is, the company has to give a clarification, but when? Sir, whenever there is a rumor, you need to give a clarification. Okay. Now amongst us, I'll tell you, people, it seems on Tata, Amir Khan is going and sitting as a director. Amongst us, let's start a rumor. Now for this, should Tata come and give a disclosure? Now let us imagine. Now I said this. Shirdi came and said this on her stories. People, do you think that she will come and tell it on the stories? Now it's again a rumor. Now this is some 40, 50. Now let us imagine now some whatever the followers are. 6 and 8,000, 700,000, 700 people. Now they're all seeing this. Now is it a rumor? Now should Tata come and clarify it? Again there was a loophole. You're telling that rumor has to be clarified. Okay, when should I come and clarify? So they gave you a in detailed explanation. What? When will the rumor has to be clarified? Whenever it comes in certain places. Now what is at certain places? They've added this. What is that? This. SEBI has notified, SEBI LODR second. The new definition called as mainstream media is added. What is mainstream media? Mainstream media shall include print or electronic mode of the following, whether it is a physical one or electronic one. So if at all it is coming here, people, then you need to give a rumor verification. So it can be electronic also, it can be physical also. What is this, sir? This means, people, newspapers. Which newspapers, sir? I'll print my own. I'll call it as newspaper. Okay, Arivu newspaper. Can't we do one thing? We can do. Now we will. So you need to define everything. So they're telling you newspaper registered with Registrar of Newspapers for India. Your Times of India. All these things will come there. Understood? Next one. Newspaper. Next one. News channel permitted by Ministry of Information and Broadcasting. Channels, your TV9, whatever are the other things you guys watch. Next one, content published by the publisher of news and current affairs, content as defined under information technology. Now, what is this, sir? Your in shorts. It can be, these two specifically speaks about your physical method or our channels. Information technology can come tomorrow in the form of OTT content. Tomorrow it can be in the form of in shorts. What is it? It's not a registered newspaper, no? In shorts. Shorts. It's not in shorts, huh? It's only shorts. Huh? Oh, I'm so sorry. This is also app. No, Noah. That advertisement. Sorry, what is that?
YouTube.
That is YouTube jobs, huh? Okay. Monitoring it. You all got no. That summary of news, the shorts it's called. Okay, that shorts. Next one, sir. Newspaper or news channel or news and current affairs content similarly registered or permitted or regulated as the case may be in jurisdiction.
BBC.
Understood? Meaning, whatever these three things are, if it is being satisfied in a country outside India, if you are registered according to their country laws, some other person outside India has reported against your company. For example, Hindenburg's report is a best example. Was not published in India. It was published outside India. Yet, by the end of the day, Adani had to give a rumor clarification. They were telling the company is about to fail. You had to give a rumor verification. So the fourth one is for same thing. Top three. Top three. All these three in India. The fourth one says jurisdiction outside India. Got it? But what is amendment? They have given you what is this mainstream media. Background is not there. That's for knowing that at any given point of time, if you feel that there is some confusion, go and read regulation 30 of SEBI LODR. That's the complete provision. Is it clear? Yes, sir. That's the first amendment. Next one, sir. Disclosure of events or information. Again, regulation 30 only. What is that? The omission of an event or information whose value or the expected impact in terms of value exceeds the lower of the following. Meaning what, sir? You need to disclose this. What? If there is any event or information, if it is exceeding the lower of the following, whichever is less. You take these three, whichever is less. If it is exceeding that, you need to give a disclosure. Now, what is that, sir? See, if there is a transaction, if there is an event, if there is an information which is exceeding 2% of the turnover as per the last audited consolidated financial statements, 2% of the turnover, 2% of the net worth, 5% of the average of absolute value of profit or loss after tax as per the last three audited consolidated financial statements of the listed entity. Meaning what, sir? A companies take consolidated financial statements and see how much of it 2% of the turnover is coming to. You'll get a value. See how much is 2% of the net worth is coming to. You'll get a value. Take 3 years average profit or loss. 3 years. Whichever is coming to a higher number. They're telling you if the number, you'll get 3 numbers exceeding this number. If you're doing any event, if you're doing any information, if you're doing any transaction, then you need to disclose such transaction. Understood? Earlier, all this was not there. They're telling you this is material. It is important. You need to disclose it on your own, so moto. Is this clear? Pakka na? Okay. Sir, in case where the criteria specified is not applicable, an event or information may be treated as being material. Now, what do you mean by that, sir? Let us imagine we are not getting this number at all for our company. We did not come in either of these three things. Then they're telling you where the criteria specified is not applicable, an event or information may be treated as material when, if in the opinion of the board of directors of the company, the event or information is considered material. So, sir, all these three conditions are not applicable for us. So, we need not disclose anything. You still have to disclose, if at all, such information according to your company's board of directors, if they think it is important. Important means what? The word used here is called material. If they think it is important, then you need to disclose that. Now, see here, the listed entity shall first disclose to the stock exchange all events or information which are material in terms of provisions of this regulation as soon as reasonably possible, and any case not later than the following. So you're telling me to disclose. Where should I disclose? You have to disclose it to the stock exchange. When? As soon as possible. But any given point of time, it should not be later than this. When, sir? Within 30 minutes from the closure of the meeting of the board of directors in which the decision pertaining to event or information has been taken. whichever is the event you're telling. People, what is that event or information? Imagine you're entering into a contract with a person. The value is really big. It's material event. You need to disclose about this within 30 minutes of the board meeting wherever you discussed it. Next one, within 12 hours from the occurrence of the event or information. In the case of event or information is emanating from within the listed entity. What do you mean by that, sir? People, 30 minutes from the board meeting where it was discussed. Next one is within 12 hours from the occurrence of the event or information. Meaning what, sir? That was a discussion. This, whatever is a scheme you guys are discussing, it is being implemented. Once you implement that, occurrence means the event happened. Within 12 hours of the event, you need to disclose. Where the listed entity initiated it. Meaning you guys are doing it. The third one, within 24 hours from the occurrence of the event, in case the event or information is not emanating from within the company. Meaning we are not doing it. Someone else is doing a contract with us, but we are having the benefit or we are having the profit. It was not discussed in our meeting. It was discussed in some other company's meeting, but we are getting the benefit. So that they are telling you, when the company is not directly the party, it is happening in some other company, then you need to disclose within 24 hours. So 3 things. Again, I'll repeat. Now, listen. First thing they are telling you, you need to disclose everything to the stock exchange. First one, rumor verification. Now, where should I disclose? I mean, when should I take it as a valid rumor? First thing, if it is newspaper, news channel, or information technology or jurisdiction outside India. If it is coming here, I have to disclose. Next one, what else I'll have to disclose? You have to disclose all those things which is material. What is material? It is decided upon your board, left to your board. Whatever your board says is material. The third thing, sir, now whatever the other things are, meaning whenever you think it is material, that is, there is a value given. What is that value given, people? Whenever the turnover 2%, net worth 2%, average 3 years, profit or loss 5%. If it is exceeding this, then you need to again disclose. Sir, if this is not applicable, then as we saw, it is left to the board on deciding what is material. And once we think it is material, you need to disclose it within 3 timelines they have given. First one, 30 minutes where you discussed. Next one is 12 hours if you guys initiated the contract and the contract happened, occurred. 24 hours. The news did not come from your company. It came from some other company. Sir, give us example. SAST. Someone is taking over the company. Did you guys do it? No. Someone is doing it. But they took over. The shares were transferred to them. The event happened. That means you need to intimate within 24 hours. Understood? Pakana, these 3 things are okay. That's what is given here. The next ones are the top 100 listed entities with effect from October 1st, 2023 in your amendment sheet. This is also an amendment. I mean, it's not, okay, wait. This entire thing is an amendment. Okay, na? Yes, sir. Can you see this strike off? This amendment is not yet there in your syllabus. I mean, it is not yet given in your supplement, but it is applicable to your exam. So you can imagine like this, there is an amendment. In that they brought another amendment and they struck off this also. You can imagine like this, there was an amendment which got in July. They said this amendment is applicable from October 23 and April 1st, 24. They brought another amendment and they said it is not applicable. So they just struck off those things in the month of November. Both are amendments only. Understood? Pakkana? 100%? Okay. So if you look at your supplement sheet, the supplement sheet is only, they have released it up to the month of September. November's is not yet given. So that's the reason this is not yet recorded. Even in the supplement sheet, this information is still there. It says with effect from October 1st, 2023. Like your, we saw no, women director, independent women director, composition of board, it is applicable to top 1000, then it becomes top 2000. So like that they introduced here also. That was later again removed. The removed part is still not yet covered in our amendment sheets. They have not yet given. Is clear? Pakka na? Okay. The top 100 listed entities and thereafter the top 250 listed entities with effect from the day as may be specified by the board shall confirm, deny or clarify any reported event or information. Understood? They have to confirm, yes, the rumor is true. They have to deny, no, the rumor is not true. I'll clarify, it is true, but this is what it means. When the event or information in the mainstream media, which is not general in nature and which indicates that rumors of an impending specific material event or information in terms of provisions of this regulation are circulating amongst the investing public as soon as reasonably possible and not later than 24 hours from the reporting of the event or information. Meaning what, sir? Whenever this mainstream media, we saw the definition, no, mainstream media. This is what I told you. Whenever there is a rumor on them, you have to either confirm or you have to clarify it or you need to deny it. Whenever it is coming on the mainstream media, you need to do it as early as possible, but at any given point of time, it should be done within not later than 24 hours. Sir, now what is considered as rumor? Everything is rumor. That is what they're telling you. Whatever is considered material, that has to be clarified and which is not available for the investing public. They do not know that information yet. That you need to clarify. Understood this part? Yes, okay. However, if the listed entity confirms the reported event or information, it should also provide the current stage of such event or information. Imagine we are telling that yes, whatever you guys have reported is true. In that, as an addition, you also have to say, if it is true, what is the status of that? Meaning, sir, let us imagine we entered into one project. Now, someone is telling that Tata has entered into a merger with any company, Ferrari. Now, there is a rumor circulating. You need to say, yes, it is true, and it is in the stage of signing of the agreement. So, you need to give the stage where it is. Understood? Yes, sir. Okay. In case an event or information is required to be disclosed by the listed entity in terms of provisions of this regulation, pursuant to the receipt of communication from any regulatory, statutory, enforcement or judicial authority, the listed entity shall disclose such communication along with the event or information unless disclosure of such communication is provided by such authority. What do you mean by that, sir? Everything you need to disclose, people. There is nothing that you should hide. You have to disclose everything unless and until there is some information which authorities only say this information should not be disclosed, it is prohibited. If such information authorities only are telling you do not to disclose, then you need not disclose. Rest of the entire information you need to disclose. From the reporting of the event or information. Reporting is whenever that news is reported. So from that time it is 24 hours. Who? Ignorance of law is not an excuse. I mean, that's what they say. I don't know. Correct? No, you cannot give it as an excuse. Which one? Applicable. It is applicable. Okay, let us do one thing. For now, you take it like this. Now, this rumor clarification. It has to be verified by top 100 listed entities. Top 100 listed entities, market capitalization. Sir, this rumor verification, should all the companies follow on? Not all the companies, top 100 listed companies. From October 1st, 2023. Top 250 companies from April 1st, 2024. Yes, sir. This is what is there according to our supplement sheet because it is only updated till September. Now, this happened in the month of November. Whatever is that date, they have struck off this. It's not yet there. Now, what is the words they have replaced? Instead of that October 1st and April, they have put this word. What? With effect from the date as may be specified by the board. So, the top 100, top 250, from when they have taken off the earlier timelines and they have put these words instead of those numbers. Now, when is that? We do not know. Correct. Is clear? Yes, sir. Pakkana. But remember both and go. First one is October 1st, 2023. Next one is April 1st, 2024. It's clear? Yes, sir. Pakkana. Okay. Okay, the last one, sir. The disclosure requirements for certain types of agreements binding listed entities. What is this, sir? All the shareholders, promoters, promoter group, related parties, directors, KMP, and employees of a listed entity or of its holding company, subsidiary, associate company who are parties to the agreements specified in clause 5A. Now, what is that? It's not there. But what is that clause 5A? I've just given for your reference. Shareholder agreements, joint venture agreements, family settlement agreements, all these agreements are given in clause 5. Now, what are they saying here? Who are parties to the agreements specified in clause 5A of schedule 3 to these regulations shall inform to the listed entity about the agreement to which such a listed entity is not a party within 2 working days of entering into such agreements or signing an agreement to enter into such agreements. What is this, sir? Let us imagine, people, there are some promoters. Now, what are they doing, sir? Let us take the example of, if you remember, SAST regulations. There was this company called as NDTV. NDTV promoters, they went and they entered into a contract with Adani to sell their shares. Now, what did they enter? They entered into an agreement called as shareholders agreement. You can also call it as share purchase agreement. Sir, is this news something to do with NDTV or is it to do something with the promoter's shareholding? Company is nowhere involved. It's my shares. Individually, I sold it. It is not company's decisions. If you guys are getting it, it is the shareholders of that company. It is his personal decision. He had shares in NDTV. He decided to sell it. Correct? Huh? They're telling you even such instances has to be reported to the NDTV within 2 days, it seems. Now the answer, why is this? Why did they have to introduce this, sir? They introduced this people because whenever these people are doing it, a promoter is selling the share, a director is selling the share, a shareholder is selling the share, there is a change in control of the company. And everyone needs to know about it. You guys cannot do it in a private way. Sir, family settlement agreement. Dhirubhai Ambani was there. Dhirubhai Ambani has 2 children. And at one point of time, he decided to divide Reliance between Dhirubhai Ambani and Anil Ambani. If you look at it, it is their family settlement agreement. Nothing to do with you guys. Correct? Huh? They can question you. Why should I tell you? You have to tell us because there is a change in control. This is what is given in the clause 5A. So if these people are entering into agreements, that agreements, whenever you guys enter into it, you need to disclose it to the company within 2 days, is what they're telling. Try to read once, see. All the shareholders, promoters, promoter group, related parties, directors, KMP, employees of a listed or holding or subsidiary associate who are parties to the agreements specified in clause 5A to these regulations shall inform the listed company about the agreement, shareholders agreement or family settlement agreement, they have to disclose about that. When within shall inform listed about which is not pay within 2 working days of entering into such agreement or signing an agreement to enter into agreement. Meaning, we are telling that we will sell the shares. NDTV's promoters, they agreed with Adani, we will sell the shares in the next month. Today you guys agreed. Whenever you agreed, from that day, 2 working days. Or when you really sold, 2 working days. You have to intimate it to the company. Understood? Huh? Sure. Huh? So these are all the amendments. Any doubts in the amendments? Pakka na? Sure. Huh? Anyone wants to submit up? Huh? Sir, Venda? Sure. Huh? Pakka na? So these are LODR amendments. Technically, as far as what I have seen, LODR has a maximum amendments. The rest is like negligible. 1 and 2 here and there is an amendment, but LODR had a maximum amendments. That is, this part was a maximum part. Is clear? Try to remember, they may ask you the definition of mainstream media. they may ask you. Clear all of you? Yes.